We're just getting started here with the Cromeens Law Firm. Did I get that? Cromeens Law Firm? That sounded right.
Yes.
Yeah.
Yes.
It's like,
A+.
Thank you. Welcome, welcome. Come on in. All right, let's officially begin. Hello, everyone. My name is Victoria Rodriguez. I'm the Executive Director of the Hispanic Contractors Association of San Antonio. And Tracy Burns is our Assistant Director. And just to take a moment, we're going to introduce our board members that are present. We have Mark Price with Alamo Colleges and Abraham Vasquez with HEB. We also want to take a moment to thank our corporate sponsors at the platinum level, HEB, Via Metropolitan, Turner Construction, Central Builders Incorporated, and Equipment Share. At the silver level, we have Bartlett Cock, CPS Energy, JSR Incorporated, Robinson General Contractors Incorporated, Skanska USA, and Joris General Contractors. And at our bronze level, Zachary Construction, Weber, RDR Flooring Services, Vaughn Construction, Frost Bank, D. Wilson Construction Company, The Blue Book, and Dawson Electric. Thank you so much, sponsors, for making these webinars and other ones possible. I'd like to introduce our presenters for today. They're from the Cromeens Law Firm. And our I'd first like to introduce Lee Leppert. She's a Senior Creative Manager at the Cromeens. Lee, hello, welcome.
Hi, thank you so much for having us.
Of course. And I'll go ahead and turn it over to you. You're going to give some of the details and introduce our main speaker.
Thank you so much. Thanks, Victoria, and thanks, Tracy, for having us today. And thank you, members, for being here. We're so glad you could join us today for our Mechanics Lien webinar. As mentioned, I'm Lee Leppert, the Senior Creative Manager at the Cromeens Law Firm. Subcontractors, suppliers, property owners, and other vendors will encounter all kinds of lien-related questions, deadlines, and paperwork when working on Texas construction projects. And it's imperative you know the lien process and how to get paid for what is rightfully yours. Today we have Jessica Mora. She is the Cromeens Law Firm lien specialist. Hi, Jessica.
Hello, good morning.
She leads the firm's mechanics lien and collections department. She's very passionate about her job and helping clients and enjoys taking on challenges. And this is something that she is your complete expert on mechanics liens. So she's shaking her head no, but she is. And she's going to be guiding us today through the time-sensitive process of filing a mechanics lien. Our main goal here at the Cromeens Law Firm is to teach others how you can protect yourself on the front end. As mentioned too, you can follow along with the handout that was sent out this morning in the email. And if you did not receive that or can't find it, you can actually access it on the HCA website and just download it there and follow along. We'll be sending out the presentation as well after today. So please note too that we have a Q&A portion at the end of the presentation. This is your opportunity to ask Jessica all of your mechanics liens questions. And I'm gonna start sharing my screen. All right, Jessica, you can go ahead and take it away when you're ready.
Good morning, everyone. Again, my name is Jessica Mora. I've been with the Cromeens for 10 years, and I run the lien and the collections department. So let's get started. So why liens are so important? The construction industry revolves around credit. Credit means all of the tiers in the construction industry are working without being paid until you're either halfway done with the job or at the end. That's the GC, the subcontractors, the suppliers, all of you are working on credit. This is the reason why mechanics liens are so important. They're securing your money on the job, pretty much. Liens are the way to secure your credit on a construction project. Liens are filed in the real property records, and they're against the property owners, even when the owner of the property did not hire you. Because the owner may never know who you are or had a contract with you with a claimant, the laws require very specific steps to have a valid lien. By following the specific steps, the owner will have to pay you even when they don't agree to. If a claimant misses one step or a sentence that is required in the notice or the lien can become invalid. And when I mean one step, I'm talking about a 0 on a zip code, any little language that is not included in your notices or the lien, you can kiss it goodbye, guys. Who can file a lien? Anyone who provides labor or materials for the construction or repair of a house, building, or improvements to a property is entitled to a lien. There's 4 different types of liens. There's a homestead, residential, commercial, public works. And I'm about to break them down, what means what. A homestead. A homestead is a residence that is owned by an individual. In the state of Texas, your homestead is protected against creditors. There's a sample. If you look at this sample, it has the mailing address that's highlighted, and it has a property address highlighted. If you look at the bottom, it says exemption type. This is someone's homestead. This protection means I can't file a lien against this property unless there's a contract signed, notarized by all the homeowners. If there's a husband and wife, married couple, both parties have had to have signed my contract. I then have to take that contract, file it a record for me to even have a lien on a homestead. So example, if an individual does not currently have a homestead and is building a new residence, which is intended to be their homestead, that can be considered their homestead. And even if they don't live there, you still can't file a lien unless you follow these steps. Let me explain this a little bit more. For example, if I am living in an apartment and I am building my custom home, my dream home, my general contractor and my bank are going to require a contract. That contract is going to be filed of record, and then the tiers that come behind that GC will have lien rights. If that contractor does not have that contract filed of record, all those other tiers do not have lien rights on my personal home. Okay? Residential, it's completely different from homestead. We all think that residential and a house are the same thing. No. Residential, I mean investment home, vacation home, if I have multiple properties. For example, if you look at this one, this individual has a home address, but the property address is completely different. In this case, the contract does not have to be filed of record because there's multiple properties. There's an investment home. You can only have one homestead in the state of Texas. So the example on this one, if you're building a residence while living in your homestead, the new residence will not be considered my homestead until I move in there. So if I'm living in my home now and I'm building my custom home, my beautiful new home, that one is not my homestead. The one I currently live in would be considered my homestead. So that contract for that build out does not have to be filed of record, and the tiers will have lien rights against that property. Residential timelines. So residential and homestead do fall under the same timelines. They just have a little bit of a different description on them. We are currently in October. So any work that was done, supplied, paint, anything that you've done to a project for the month of August and you have not been paid by the 15th of October, the first notice should have gone out. First notice goes to the general contractor and the owner. This is what we call the intent to lien stage. If by November 15th, you were not paid for material supplied, paint, sheetrock, whatever work you did, your lien has got to be filed with the county by the 15th. When I say by the 15th, I mean by the 15th. If it falls on a Saturday, if it falls on a Sunday, if it falls on a holiday, make sure you do it the day before. I do personally do not like to wait to the 15th because you never know. But by the 15th is your deadline for that lien to be filed. If you miss that notice, you are not entitled to a lien. That lien will be invalid. commercial jobs. Please notice that I put spec houses. When I say spec houses, I mean D.R. Horton, David Weekley, the big builders. All of those houses are meant to flip. Yes, it's better to keep them on a residential timeline because those houses move very fast, but they are not considered residential. They are considered commercial. Warehouses, shopping centers, private schools, anything that has to do with a commercial job. If you look at the sample, it's going to give you the address. This sample here we got off of the CADs. Any county records will show you the status class code. It'll tell you residential, homestead, it'll tell you commercial, it'll tell you public works. This property, as you see, it has no exemptions. Most commercial constructions projects have the following tiers. You have your owner, your general contractor, your subcontractor, and your supplier. Again, back to our tiers, the reason all these notices are so important is because the owner hired the prime contractor. The prime contractor and the GC are the ones that are in this contract together. The owner usually will never know who is on these jobs. The GC has a contract with the subs, so the sub will not know who your suppliers are. The subcontractor agreement with the GC, so they won't know who the owner is. My screen just went black. Did anybody? Okay, there we go. Sorry. The agreement is with the GC, so they don't know who the owner is. The supplier has the agreement with the subs, so they don't know who the GC is or the owner. No one knows. You will never know who anyone is unless you ask or you send your notices or you do a little bit of research. Ask the question. It's okay. They will, if they don't want to answer you, there's a reason why. So this is your timeline for non-residential, which is all commercial. Again, we're in October. So the first notice for August was just to the GC. This one includes that first notice. We like to call it a GC notice because you only have to notify the general contractor or the prime contractor. Second notice goes to the owner and the general contractor. Your third is your lien that has to be filed. Please remember, if you miss one of these notices, your lien can be invalid. Public works, fire stations, police stations, schools, anything owned by the county or the city is considered public works. If you guys look at the status class code, you're gonna see it's exempt. It says government. If it is a government project, you do not have lien rights because they're owned by the city. You don't have lien rights, but they do have what's called a payment bond. GCs are required the payment bond on public works. You will have to file a claim with the insurance if you're owed any money on these jobs. When you're filing a bond claim, those notices are very particular. You have to have the bond number. You have to have the information for the insurance company because you have got to send notice to them. Their timelines are a little different as well. Your first notice does go to the general contractor and the insurance company. When you're sending a notice, it's not just a plain notice. It is an affidavit. You are swearing that you did this work and that you're owed this money. These notices, again, very, very important. Your first notice has to go out by October 15th. For any work done in August, that first notice will go only to the general contractor. You're letting them know at that time, I'm owed money, and before I file my claim, please pay me. If they choose not to, that's the next step, which would be November 15th to the insurance company. At that point, you're notifying the insurance company, I have not been paid and I need to be paid on this job. A little bit of a breakdown on ours. So collections, GCs usually have what's called a constitutional lien. I love constitutional liens personally because you don't have to do any of the steps. Pretty much, you just file your lien because you're in direct contract with the owner, so they know that you're there. They know that they owe you money, so you don't have to send any notices at all. You do have to you have to file your lien. I'm lying, I'm sorry. Let me go back. when I say you don't have to send any notices, the only notice you send to them is when you file your lien, you have to notify them that you have filed that lien. Subcontractors, suppliers, you will have to follow the statutory guidelines. So, which means your notice is on time. So I like to have what's called a job info sheet. We kind of tell all of our clients to have this in the front end, which makes it so much easier if you have to do any of these notices. I like what's called a job info sheet. This will usually have the project name, the exact address of the project, the GC information, their phone number, and any owner information that you can possibly find. Owner information is not that hard to find, guys. Every county, if you Google a zip code, what county is 77024 in, it's going to tell you the county. That information, you put Harris and then put the county appraisal district, you look for the address. The address is going to tell you if it's a residential, commercial, public works. It's going to give you the information for the owner. It's going to tell you who owns it. The only thing I have noticed is you have to make sure that it says real property, because it'll have real property, but then it'll also have personal property if they're leasing the space in that building. So just pay attention to that. Again, you're looking at the state class codes. You have residential, commercial, and exempted. Exempt means government owned, public works all the way. To verify your GC information, Google works like a charm, but if you have a Secretary of State account, you can actually look them up and find out who their registered agent are and get their exact address. The Texas Comptroller will also tell you if the company is actually an LLC, incorporated in any type of way. They will also provide you with an address and, a mailing information that should be good for you. So this is an example a little bit about our notices. Residential, we're going to go into residential. The first statutory notice is an intent to lien sent to the owner, general contractor, and your customer. If you're a supplier, I like to include my customer. If not, you're fine just by including the owner and the GC. It must be sent out by the 15th of the month, certified mail. Remember to include your invoices or statement of account. I don't know how many people I have seen that do not include invoices or a statement. Your lien can be invalid just because of that. It doesn't matter if you supplied at the beginning of the month or at the end of the month, it all falls under the same timeline. When I tell you guys, this is January sample. If I did work January 2nd, or I did work January 27th, they all fall under the same time frame. At the beginning or the end. It doesn't matter when you did your invoice. I don't care if you did work January 25th and you didn't invoice till February. That is still considered January's work. So it falls under March 15th. If you miss the intent notice or send the wrong address for any reason, do not file your lien. It will be invalid. There is a $10,000 penalty for filing invalid lien. Liens filed of record by the 15th of April in the real property records, where the property is located. Liens must include the owner, the GC, the customer information, who your agreement was with, the legal description, what type of work did you do, and the date your notice was sent. The date the intent was sent. If you did not send that intent, your lien will be invalid. A copy of the lien must be sent to the GC, the customer, the owner, within 5 days of filing that lien. When I say 5 days, I mean if I file my lien today, I have 5 days to send them notice. I do not have to wait to get my recorded copy back and then mail it out to them. I can easily mail them a copy of what I am filing of record. Commercial projects, you have that extra notice. The first notice is just sent to the GC. Again, suppliers, if you have a customer, I would send them the notice as well. Remember to include your invoices and your accounting statements. Note, it does not matter if you supplied at the beginning or the end of the month. They all fall under the same timelines. Second notice goes, it's the intent to lien notice that goes to the GC and the owner by the 15th of April. Remember, return receipts are required. Remember to include your invoices and accounting statements. If you miss that first notice, suppliers, or a subcontractor, second tier, I'm a sub of a sub, and I did not send that GC notice to notify the GC. You have to remember, they do not know who you are. They did not hire you. If you do not give them that notice, your lien will be invalid. There's a $10,000 penalty for filing an invalid lien. Liens are filed with the real property records by the 15th of May for January work. Again, lien must be sent to owners. You must include the following information: owner, GC, customer, who your agreement was with, your legal description, when, what type of work did you do, and the date the notice was sent. Notice of the lien must be sent to the owner, GC, customer within 5 days of filing. Remember that 5-day rule. Public Works. If I supplied material or labor in January, my first notice, again, to the general contractor. In this notice, if you do not have a copy of that payment bond, please put a note in there to request a copy of the payment bond if you know who the real GC is. Again, it doesn't matter if you supplied at the beginning or the end of the month. The bond notice is a second notice to the GC, the insurance company, the owner, and it must be sent out by the 15th. Certified mail return receipts. It has to include the sworn affidavit along with a copy of the payment bond and your invoices. Certified mail is very, very important. I know we're in a different era, but this is the dinosaur stage where, yes, please send it out certified mail. Take it to the post office. Get this little receipt stamped. I don't know how many times I can pull that out and show that it was actually stamped at the post office and save my clients money by doing that. We're going to go into a little bit about waivers. So the state of Texas has provided us with 4 statutory waivers. These are the waivers that we should be using, that everybody should be using. Of course, everybody wants to do it different and include some verbiage that does not need to be included. There's 4. There's conditional on progress, conditional on final, unconditional on progress, and an unconditional on final payments. Conditional on progress. Let's break it down a little bit. I'm hoping everybody should know this, but just in case. This waiver is in exchange for a check payment that has been received or that is being mailed. So I can say, I will give you a conditional on progress because I am not done with your job yet. I am waiting for a payment. I am going to receive a payment, but I am not completely done and you still owe me money. I will send this if they're going to mail me a check. Not a problem. A conditional on final payment. This means I'm receiving a final check. I'm going to give you this conditional on my final payment. Do not sign this on final payment if it's not the final payment. And when I say final payment, I mean you are completely done. Retainage falls under final payment. Please do not sign this if you're still owed retainage. An unconditional on progress. I received partial payments for my 3rd draw. It has cleared the bank. I am good with that payment. Please make sure to put in there the amount that you're really being paid for on that draw. Remember to deduct the retainage for the draw. Remember to include what date they're paying you through. If I'm getting my first draw for work done in January, I would put this payment is for through January 31st. This payment is, what do we say, 10,000, but I'm gonna subtract my 10% that they're still withholding. So technically it's 9,000 and I'm being paid through January 31st. Fill them out. It's okay, guys. Fill it out the correct way. Unconditional on final payment. I have been paid everything, including my retainage. Again, if you are owed anything, do not sign the unconditional. It is, if you see the notice at the top of the unconditional, it is telling you, if you have not been paid in full, do not sign this. Use a conditional release form. These are provided by the state of Texas. Please use these waivers. Retainage, my favorite. It's so complicated. By enforcing retainage, you can learn to protect yourself, your money, time, resources in your construction project. The retainage is allows the client to only pay a portion of the payment for the project and withhold the rest until the project is complete. Retainage protects the owners, guys, not you. Retainage is a standard practice within the construction project, and it's required by nearly all construction loans. It is a 10% of the contract amount between the owner and the original contractor or the GC on the project. Although the legal definition of retainage says nothing about subcontractors, most original contractors take 10% from the amount due to the subcontractor throughout the project. Every contractor an owner hires directly is called the original contractor. If any owner hires all of the trades directly, each contract is an original contract. This is important because all lien claimants could be limited to only 10% of the contract where they were supplied labor or material. Retainage is not our friends, okay? If the GC decides to not pay 6 suppliers and subcontractors, and the owner properly withheld that 10%, all of those claimants are only entitled to that 10%. It's not fair, but that's the way it's also there to protect the owners. Why is retainage important? First, it adequately withheld. Retainage is essential because it can limit the owner's liability. For example, if the owner withholds 10% of the entire project amount from the original contractor, they have to withhold it 30 days after final completion. The owner's only liability to lien claimants will be that 10% if the amount of the lien claimants exceed the retainage amount. The valid lien claimants will share the 10% on pro rata base. Second, if the owner properly withholds the 10%, the time frame for filing a lien can be shortened. If the project is completed, an affidavit of final completion is filed with the county clerk and the owners withhold the 10%. Remember that let me step back. If you're the last tier coming in to finish up a job, you only have 30 days from final completion to file your liens, which means all the notices that you're supposed to send have to be sent really, really fast. The timeline doesn't matter at that time. You can do everything early, you just can't be late, but 30 days after final completion is all the time frame you have. Remember that all liens must be filed within 30 days of final completion. Normally, a lien claimant has until the 15th day of the 4th calendar month, after the last material is supplied, to file its lien. Time frame can be shortened by the 30 days after final completion if the owner follows the steps above. Remember, if they properly withhold that 10%, you are now only entitled to file that lien 30 days after final completion. Retainage generally does not become due to the subcontractor until 30 days after final completion and or when the general contractor receives the retainage payment. This ensures that the subcontractors will have a valid lien on retainage and that they should file their liens at the completion of the project. Retainage is very, very tricky. We deal with it every day. I can tell you that what we've done in the past is as soon as our clients are done, we'll start sending out our notices and file our lien. Again, you can always be early, you just cannot be late. So that is the end. Please let us know if you have any questions. I will gladly answer them for you.
Thank you, Jessica.
You're
Thank
welcome.
you.
I think Lee's going to handle, Lee, did you want to read those email questions?
Yeah, absolutely. So we actually received some great questions. Thank you, Robert Lozano. We really appreciate it. So I'll just start with a couple questions that he sent over, Jess. So does the mechanics lien only apply to new construction?
No. Nope. Build outs, remodels, those count as well. Just remember residential, homesteads, commercial, those timelines you have to remember, but no, it does not only apply to new construction.
Okay, thank you. When you file a mechanics lien, how long does it last? How many years?
When you file a mechanics lien, residential, homesteads, or residential projects, you have 1 year to file a lawsuit to foreclose on your lien. Commercial, you have 2 years to file a lawsuit to foreclose on that lien. When we say that, the lien's never really going to go away until you release it. But to enforce your lien rights on residential, it's 1, on commercial, it's 2. If you do not enforce those lien rights, those owners can easily send you a notice and let you know you have to remove this lien. And if they don't, at that point, since your lien becomes invalid, they can sue you to remove your lien.
Perfect, thank you. Another question is, do you need lawyers?
You don't. You can do it yourself. Do I recommend y'all do it yourself? No. Trust me, I can count, well, I can't count it on my hands, how many liens we've seen that they do it themselves, and then I have to go back and be like, it's no good. And it's not that it's not good, it's just you missed a step. You missed some information. There's something wrong with it. You sent the notice to the wrong owner. You sent, any little thing can throw it out. So yeah, you can do it yourself. I don't trust the come out right. I'm sorry.
Yeah. So AKA call Jessica, the Cromeens law firm.
But Jessica, more than that, if I understood what you were explaining, is you can actually be fined for having an invalid.
Yes,
I mean, it's not just about your lien won't be accepted. It's like you can actually be fined.
You can, because here's the thing. If the situation that I've seen constantly is, I'd be like, your lien is invalid, release it. And the person that is owed money is pissed because they're owed this money. I did this work, I deserve to get paid. And you are totally right. You deserve to get paid, but you didn't do it right. And you're clouding up the title for that owner. And that owner had no contract with you. Mm-hmm. So you're tying up their property, but they had no idea who you were. Okay. So how is it their fault as well? Do you see what I mean? So when they say, yeah, I'm going to sue you to remove it, there's a penalty for that. You're clouding up their title and you didn't follow the right process. So therefore, you do have recourses. Yes, you can go file a suit against the person that hired you. But then again, that's very expensive.
And it almost sounds, because of these timelines, kind of having an eye on it, we deal a lot in the small minority women veteran-owned businesses. So, I mean, the staffing is usually, in some of these cases, 1 or 2, people doing it, they do their books in the evening or on the weekend. So I can't imagine when you get into these scenarios, does it make a lot of sense to engage an attorney when you start a project rather than when it's time to file the lien? I mean, do y'all do that quick of a turnaround? Like, hey, I just finished a job. Can you help me with this lien?
So what we've done in the past is we've kind of trained our clients, because I have mom and pop shops all the time. I have it where the wife is the one doing the books and the husband's the one outside. Yes, that's the way we work. I get it. I understand it. So we've actually gone into their office and be like, here's what you do. When you pull your ledger and you show that it's now about to be 3 months and you're owed this money, send this notice. Just
Okay.
send this one, right? If you don't get paid with that first one, then we go to the second one. At that point, you
Okay.
can call me and I'll help you out. But we
Okay.
show them how to do it. We
Right.
want them to learn the process.
Okay.
And you're going
Okay.
to know. I cannot express how many times I tell all my clients, pick up the phone, call them, call
Mhm.
everybody, stir up the
Yeah.
pot. That's what you have to do. You
Mhm.
have to call them. They don't know who you are. And I'm sorry, I'm going to be honest. The project manager is not the one that's going to pay the bills. Call the
Mhm.
office, call the
Mhm.
accountant, call accounts payable, send an email. Calling people gets people's attention.
Mhm. Mhm. And I think for a lot of people, calling an attorney sounds like the bill just starts
It does.
racking up.
Yes,
But
it
I
doesn't.
think, well, and I think you guys have been our members for a while, and I feel like the message has always been a resource. I mean, certainly, when the time comes, like, yes, your certain services have to be paid for, but here you are today giving your time to explain some of these intricacies. But I really hear you saying, just call, ask, you just really don't know until you ask and kind of start that conversation, because the training that you just mentioned is amazing. Just to kind of explain that process and have them catch on, and then they're good until it hits a certain point.
Yes, I have clients that I've had for years, and they'll just be like, Jessica, can you look this up for me? Yeah, sure. Or and I'm like, why did you do that? And she's like, well, I just looked. You have my number. Just call me. I will tell you. No, don't do that. Yes, send it out. This is where you
until
send it to.
you're passionate about it.
I am very passionate about this. This is my baby.
Okay,
Yes.
I'll pass it over to Lee. I think there's some
Thank
more
you.
questions.
There she
Go
goes.
ahead.
Yes, I'm back. Lost some power. So I'm not sure what was just asked, but I know there's a couple questions from a couple more from Robert.
Okay.
And he asked, if your contract dictates an arbitration clause, can you still file a lien?
Yes, you can. A lien. So your subcontract agreements call for arbitration, call for mediation, or they'll say you have pay when paid clauses. That does not prevent you from filing a lien. You can file a lien as long as you're not paid. Remind you, you can file a lien for work that you actually did. Do not file a lien for an entire contract amount when you left halfway through the job. Okay. Now, if you left halfway through the job, there's probably going to be issues, but I get when I tell you you're working under credit and you can't upfront the cost of an entire project. Make sure you have your contracts read before you do that. If you are going into a job, please have your subcontractors, please make sure you have read that contract fully and that you understand every detail of it. There's a lot of tricky things in those subcontract agreements.
Absolutely. And if the prime has a government contract, can you still file on a government property?
Bonds. That
Bonds.
is what we say. It's a payment bond. It's a payment and performance bond, but bond claims. You don't file a lien, you file what's called a bond claim.
Okay.
Okay, so on another note, see, I told you I'm going to keep going. So on bond projects, bonded jobs, which is government owned, those bonds are not filed of record. You have got to dig for those bonds. When I say dig, I mean, I will call the GC's office. I will send them a demand letter. I will call the city. I will call everybody to get a copy of that payment bond. They do not like to just turn those over, because if the bond company pays out, they can't ever get a new bond. So it's important to make sure you follow that process very thoroughly.
Perfect. Thank you so much. And can you file against the prime contractor if you're from a different state, if you're both in different states? Is that something that, if it's not in Texas, then?
Your lien is filed against the owners, not against the GC.
Mm-hmm.
So you're filing against the real property itself. You can file suit against the contractor if he doesn't pay you. That's a breach of contract. That's something completely different. But filing a lien, it actually goes on the property that you did the work.
Right. Perfect. Thank you. And I wanted to make sure, Victoria, did you get a question from Mark
Yes.
Price? Okay.
Yes.
Perfect.
Can I start with the one, it's in the
Yeah.
chat from Veronica Ovalle. Do you have templates of the letters to send?
So we have a template of the first notice, which is the GC notice. It's a basic letter. But the intents and the lien notices, we don't give those out. Sorry.
Okay. Okay. Okay, and then we're going to go through, actually, a couple of board members joined us. Christian Cortez, he's with Bartlett Cock, and we also have our president, Daniel Salinas, he's with Central Builders. So Christian asks, can you file one lien to cover multiple projects?
No, every project, if it's on the same, well, let's say, if I'm filing multiple liens for, I have a glass company who's a client, and they did apartments. If they have 1 building, 2 building, 3 building, yes, I can file on each building. Now, if I'm filing under, I have the same GC and I have 3 different jobs at 3 different locations, each location has to have its own lien.
Because location determines the
The
owner
real property,
of
the
yeah,
owner,
real property.
the legal description, all of those are all different. So I can't.
So really,
file
it's
them.
determined by the
The
appraisal
legal
district.
description and
Okay.
the owners.
Okay. Mark Price asks, are there any things to be aware of when the work is involving an insurance claim from damage and you have your lien for your portion of the work?
Repeat that one for me.
Any things to be aware of when the work is involving an insurance claim from damage? So there's an insurance claim from damage and you have your lien for your portion of the work. So maybe there was damage
Would
to...
it be residential or commercial?
Mark, if you can follow up on that, we'll come back to it. If you can ask a follow-up and clarify. Meanwhile, Daniel asks, when you file a bond lien, does the owner get the bond letter or the general contract?
You're sending it to the owner, the general contractor, and the insurance company. You have to send it to all parties.
Okay.
If you
So
don't,
it's covering your
you have to send it to everybody or your bond claim is moot.
Okay. Okay, let me see if Mark can clarify. So I wonder if he's, I'm totally guessing here, but if he's referencing if there's damage to the property and therefore maybe the work can't continue, or.
So here's the thing. Okay, I can answer it, but I'm just breaking it. I'm gonna break it down to commercial or residential. If you did work that the insurance company is paying out on a residential job, you're fine to file a lien, but your contract between the owners, if it's husband and wife, both of them have to sign that contract. You then have to take that contract and file it in the real property record to be able to have lien rights. If you don't do that, you don't have lien rights on that home. Commercial, you can file a lien as long as you follow your timelines. If it's even if the insurance is paying it out, you still have lien rights.
Okay, you actually covered it because he said either residential or commercial. You got it. Okay. I think that seems to be it. Let me double check the chat. Yeah, no, that seems to be it. And I want to go in and mention, Lee, or maybe you were going to cover this, but we are going to make sure that you all have the contacts of people that registered, and that way there can be kind of a follow-up conversation possibly, because just like you said, they need to just call you and ask.
Yes.
and then we'll see where that goes, right? Yeah,
that's great. Yeah, we would love to do that, and we'll be sending, we can have the presentation that we showed today, so that's perfect, and we'll definitely love to follow up with everyone.
Okay, well, I can't thank you both enough. Obviously, attorneys' time is money. Every what is it? Every quarter hour counts. I'm not even sure. It's every 7 minutes or something. But this was definitely a freebie for us from Jessica. We sincerely appreciate that. And
no problem. You're welcome.
Yeah.
I hope
and
I answered
Lee,
everybody's questions. I hope it was
I
okay.
think, I think so. Even
Okay.
even the ones you had to,
Very
you had to
informative.
guess.
I know I learned a lot.
Yes, yeah, definitely. And Lee, thank you for that. As I mentioned off camera, that it was a very snazzy presentation. I really enjoyed the
You're
the
so
effects of
welcome.
it. So we'll have to
Of
look up
course.
Prezi ourselves.
Yes.
Yeah, if there's nothing else that you two need to add, anything else?
Thank you guys. Give me a call if you have any questions. Please don't do it yourselves. Please don't.
Yeah, that we got that message. That's for
Yeah.
sure.
Yes. Yes.
All right. Well, thank you both for your time. We do appreciate the Cromeens Law Firm, their membership with us, but especially for these types of outreach. We look forward to seeing you again. Maybe we're talking about a series with the Cromeens, so we'll look into that possibly. Yeah, but I think that wraps up today. We were trying to be time sensitive so everyone can get back to their jobs, and we hope this was helpful. We do have a mixer, everyone, tomorrow evening, in-person mixer at Augie's Barbed Wire. That's on St. Mary's Street, beginning at 5:30. The presentation by Via, it's just really light. It starts at 6, and then we're going to move into the mixer portion. So hope to see you all there. Register on our website. And I think that is it for us. Thank you so much.